Imagine a man is standing outside your window in the dark.
Just lingering right outside the glass.
Exactly.
Yeah.
I mean, it is late at night, the streetlights are dim, and you are inside what is supposed to be your sanctuary.
Or what you think is your sanctuary.
Right. You look up, and there is a stranger staring intently at you and your child through the glass.
It's just a terrifying scenario.
It really is. So the police arrive, they arrest him. The community is obviously terrified. And then the court system looks at the situation and basically tells you, sorry, the punishment for inflicting that kind of, psychological terror on a family is actually less severe than the punishment for simply stepping on your front lawn.
Which just sounds completely backwards.
It sounds insane. But welcome to the bizarre, incredibly complex reality of local justice. You are listening today because you don't just want the sanitized headline or, the simple narrative.
Right, you want the actual details.
Yet you, the learner, want to see the blueprints. You want to understand how the machine actually works when it is processing human behavior on a daily basis. So today, we are taking you on a customized, highly detailed, deep dive into the local justice system in Texas, specifically zooming in on the granular reality of Bill County.
And it is an incredibly revealing cross-section of American law. I mean, we so often think of the justice system in these grand cinematic terms.
Like big dramatic courtroom movies.
Exactly. We picture the Supreme Court handing down sweeping constitutional decisions or dramatic trial verdicts that change the course of history.
Right.
But the actual reality of the law, the place where the state truly intersects with the lives, the freedom, and the wallets of everyday citizens, that happens at the county level.
It's super local.
It is hyper-local, it is relentlessly bureaucratic, and it is largely driven by paperwork, minor statutes, and just a sheer volume of cases that the system was never originally designed to handle.
To understand that machinery, we really have to look at the raw data it produces. I mean, we aren't looking at textbooks today. We have a stack of highly diverse, completely authentic source documents to guide us.
And they are fascinating documents.
They really are. We are pulling from local news transcripts detailing an ongoing community crisis, an incredibly dense, raw 2026 county jail inmate roster.
Which is just a staggering document to look at.
Oh, it provides a fascinating, almost overwhelming snapshot of society. Plus, we have a formal political campaign announcement and a deeply technical Texas Supreme Court disciplinary order.
So what this collection of documents gives us is, well, it's a multi-dimensional ground-level view of a system that is really struggling to maintain order.
Yeah.
We are going to explore 4 very distinct facets of this machinery. We will examine the friction that occurs when rigid penal codes encounter chronic psychological threats.
Right, the stalker situation.
Exactly. Then we will analyze the overwhelming logistical reality of a county jail log and what that data actually reveals about the intersection of poverty and criminal justice.
It's a lot to unpack.
It is. We will also look at the tools citizens use to actively challenge the state's authority. And finally, we will dissect the insulated, heavily protected process that occurs when the legal professionals themselves fail to uphold their fundamental duties to the public.
If there is a unifying theme to what we are exploring today, it's really the concept of the bureaucratic grinder.
That's a great way to put it.
We are going to see how the system processes people, how it fails to process certain types of harm, and who ultimately bears the burden of those failures. Okay, let's unpack this.
Let's do it.
Let's start with a scenario that tests the absolute limits of the penal code.
Oh,
We have a 45-year-old man named James Austin Grisham.
okay.
According to the news reports in our sources, he's an alleged serial stalker and a peeping Tom. And I want to be clear, when the source material uses the word serial, it is not an exaggeration at all.
No, the numbers are kind of shocking.
The court records show that this individual has a staggering 28 arrests in Bell County alone since 2005.
28 arrests within a single local jurisdiction is just an enormous administrative footprint.
It really is.
I mean, it immediately signals a systemic failure. It indicates a deeply ingrained pattern of behavior that the judicial system is repeatedly interacting with, expending resources on, and yet totally failing to permanently resolve or deter.
Right, because he just keeps coming back.
Yeah.
Let's walk through the timeline provided in the sources, because this sequence of events is just agonizing for the community.
It's a very tight timeline, too.
It is. So in June, Grisham is arrested. The investigators clearly outline his method of operation, his MO. It involves walking up to private homes under the cover of darkness and looking directly into the front windows.
Right, so he's using the night to his advantage.
Exactly. This isn't an isolated incident of someone getting lost or confused. It's a calculated, repetitive intrusion. So he's processed, he serves his time, and his sentence officially ends in August.
Only 2 months later.
Yeah, he is released back into the exact same community.
Uh-huh.
And then, practically a month later, in September, he is rearrested for criminal trespassing again.
It is the literal definition of a revolving door.
Seriously.
To understand why that door keeps spinning, we have to look closely at the specific victims and, more importantly, how the legal statutes categorize the harm they are experiencing.
Yeah, the sources center on the perspective of a specific victim, a Temple resident named Micah Springsteen.
And her experience is really the human element that gets completely lost in the statutory language.
It really does.
Yeah.
Micah Springsteen's experience is terrifying. Grisham approached her house. He stood outside and looked at her and her daughter right through their windows.
Just staring in at them?
Yeah. The sheer violation of that act is profound. I mean,
Yeah.
you are in your home, which is conceptually and legally supposed to be your ultimate safe harbor.
Right, your castle.
Exactly. And the perimeter of that safety is pierced by a man staring at you and your child in the dark. Micah didn't just hide, though. She became a highly vocal advocate.
Which takes a lot of courage.
It really does. She went on the local news to state clearly that the community in Belton and Temple has voiced their opinions loudly. They do not want this individual on their streets.
And you can't blame them.
Not at all. And the overarching sentiment she expressed was a deep, palpable frustration that the district attorney and local law enforcement seem entirely handicapped in their ability to stop him.
And, that perception of law enforcement being handicapped is actually entirely accurate.
Wait, really?
Yeah, but the handicap is not a lack of effort. It is a lack of statutory authority. This is where we really need to dissect the legal mechanics.
Okay, lay it out for us.
We have to ask the fundamental question. Why does a man with 28 arrests, who is allegedly stalking and terrorizing families, continually cycle back out into the public?
It just doesn't make sense to a normal person.
Right. So we have to turn to the legal expert cited in the news reports, Jeffrey Lennox, who breaks down the precise wording and categorization of the Texas Penal Code.
Okay, so if I am a police officer responding to Micah Springsteen's house, and I catch this man looking through the window, what exactly am I allowed to charge him with under the law?
According to Lennox, the specific peeping Tom aspect of this behavior, the visual intrusion into a private space, that falls under a statute called voyeurism.
Okay, voyeurism.
And under the Texas Penal Code, voyeurism by itself is classified merely as a Class C misdemeanor.
Wait, let's define what that actually means in practice, because that categorization is jarring.
Yeah.
A Class C misdemeanor implies what level of punishment?
In Texas, a Class C misdemeanor is literally the lowest level of criminal offense.
Wow.
It is typically punishable by a fine only up to $500. There is zero statutory possibility of jail time for a standalone Class C misdemeanor.
You're kidding.
No, it is treated administratively with the same severity as a traffic ticket.
That feels entirely disconnected from the reality of the crime. I mean, handing someone a ticket for traumatizing a family.
It does feel disconnected.
But the sources note that he is getting arrested for criminal trespassing, not just voyeurism. How does that shift the math?
Well, Lennox clarifies the critical distinction here. If the individual remains on public property, say a sidewalk, and uses binoculars to peer into a window, that is merely voyeurism.
So, ticket only.
Right. However, the moment the individual physically steps over the property line, entering the premises without the explicit permission of the owner to peer into that window, the charge elevates.
Because he's on the grass now.
Exactly. The physical intrusion onto the land triggers criminal trespassing. And the first offense of criminal trespassing is a Class B misdemeanor.
Okay, and a Class B misdemeanor carries a totally different set of consequences, right?
Yes. A Class B misdemeanor is punishable by up to 180 days in a county jail, along with a potential fine of up to $2,000.
Okay, so the system can hold him for a maximum of 6 months. And once that 180th day hits, his sentence is done. The penal code demands his release.
Precisely. He serves his county time, the statutory requirement for the punishment is fulfilled, and he is released.
Back to the streets.
Right. And as the news reporter explicitly noted, he can continue committing these exact same offenses. He can rack up a 29th arrest, a 30th arrest, and he's never looking at big time in a state penitentiary because the core action remains a misdemeanor.
That's just wild.
Yeah, there is no automatic legal mechanism in the standard trespassing statute that elevates the crime to a felony simply because of repetition.
So I really have to pause here because the logical disconnect is staggering to me.
It's hard to wrap your head around.
The act of looking into someone's window, The act of violating their psychological safety and terrifying a mother and her daughter is punished strictly with a fine.
Yes.
But the act of stepping on their grass, the physical trespass, is what actually carries the threat of 180 days in jail. The law is essentially prioritizing the physical dirt over the human mind. How did we end up with a penal code that operates like that?
It is a profound contradiction, and it stems directly from the historical evolution of our legal framework.
Okay, take us back.
If we trace the lineage of common law, which forms the bedrock of our modern statutory systems, it was developed centuries ago in an agrarian society.
Right, farmers, landowners.
Exactly. In that context, property rights were the absolute paramount concern of the state. The physical boundary of the land, the crops, the livestock, these were tangible, measurable assets that the law could easily define and robustly defend.
Right, the concept of a man's home being his castle was about defending the physical walls against a physical siege, not necessarily about defending against a psychological intrusion.
That's exactly it. Safeguarding the abstract concept of psychological well-being or protecting the modern notion of visual privacy within the home, these are incredibly recent legal concerns.
They just weren't thinking about it back then.
No, our statutes are highly adapted to punish discrete physical actions. You stole a horse, you broke a window, you struck a person.
Great cut.
The system knows exactly how to weigh those actions and assign a penalty. But it is remarkably clunky when forced to deal with a pattern of psychological terror that doesn't involve physical violence or the destruction of property.
Yeah.
A serial stalker inflicts immense cumulative trauma, but because the individual actions, stepping on grass, looking through glass, are physically minor, the 19th century logic of the penal code simply cannot process the severity of the 21st century harm.
Wow. So the community in Bell County is dealing with a system that is functioning exactly as it was designed to function, but the design is fundamentally flawed for this specific type of threat.
Beautifully put, yes.
Law enforcement knows he is a menace, the community knows he is a menace, but the police are bound by the text of the statute. So if the front door is locked by the penal code, how do authorities keep a man with 28 arrests off the streets? They have to find a back door, right?
They do. They are basically forced to engage in legal engineering.
Legal engineering, I like that term.
The judges, the district attorney, and the sheriff's office cannot rewrite the statutes themselves, so they have to manipulate the existing rules to construct a more severe penalty.
Okay.
The sources detail two specific bureaucratic tools the local justice system is attempting to utilize to break this endless loop.
Let's break down the first tool, manipulating the bail system.
Right. So when a defendant is arrested and brought before a judge for arraignment, the judge must determine the conditions of their pretrial release.
Which usually involves setting a bond amount.
Exactly. Legal expert Jeffrey Lennox explains that a judge is generally weighing two primary factors during this process. First, is the defendant a flight risk? Will they actually show up for their scheduled court appearances?
Okay.
And second, what is the potential danger to the community if this individual is released back onto the streets pending trial?
Well, given the MO we discussed, a man with dozens of arrests who peers into the windows of families at night is an undeniable danger to the community's peace of mind.
Absolutely. So the judge presiding over this latest arrest decided to raise Grisham's bond by $5,000.
Just to make it harder.
Lennox points out that this is a deliberate tactic. A judge can set the bond amount high enough that it creates significant financial friction for the defendant.
Right.
If the bond is elevated, the defendant might not have the cash on hand, or they might not be able to afford the non-refundable premium a bail bondsman would charge to post a surety bond.
So it is a way to use economics to achieve temporary incapacitation when the criminal statute alone won't suffice.
Exactly.
But bail is just a pretrial holding pattern. It doesn't solve the underlying problem of the sentencing limits. If he eventually pleads guilty to the misdemeanor, the bail money is a moot point, and he only faces those 180 days.
Yeah, that is the absolute limitation of the first tool. It's temporary. The second tool they're utilizing is far more intricate, and it represents a fascinating, albeit troubling, workaround by the justice system.
Tell me.
They are leaning heavily on the strategic use of protective orders.
Okay, this was the absolute turning point in the source material for me. Because, as we established, Grisham can rack up criminal trespass charges endlessly, and they remain Class B misdemeanors.
Right.
But Lennox highlights a vital statutory difference when a protective order is introduced into the equation.
A protective order fundamentally changes the legal landscape here.
How so?
If a judge issues a formal protective order, for example, on behalf of Micah Springsteen, legally mandating that Grisham stay a specific distance away from her and her residence,
Okay.
and Grisham violates that order by returning to the property, the first violation is a misdemeanor.
Still a misdemeanor.
If he returns and violates the order a second time, it is still classified as a misdemeanor.
Okay, so we're still in the loop.
However, the Texas statute contains an escalator clause for protective orders. If he violates that order a third time, the law mandates that the charge automatically elevates to a felony offense.
Oh, wow. So think about the mechanics of what is actually happening here. It is as if the community is being forced to build a legal electric fence around their own homes.
That's a really good analogy.
The physical fence around the yard isn't keeping him out. The standard penal code isn't working because the punishment is a revolving door. So the victims themselves have to personally take on the administrative burden.
You have to do the heavy lifting.
Yeah, they have to go to the courthouse, they have to file the civil paperwork, they have to stand in front of a judge and recount their trauma to secure the order.
Which is traumatizing in itself.
Right. And then once the invisible trap is set, they essentially have to wait in their homes to be victimized 3 more times before the system is finally authorized to trigger a felony charge and put them away for a significant amount of time.
The analogy of the electric fence is perfectly illustrative because it highlights the transfer of responsibility. The state, through its standard policing powers, just cannot solve the problem.
It's impotent.
Therefore, the state requires the victims to actively participate in the escalation of the legal consequences. Law enforcement becomes dependent on the victim's administrative diligence.
Wow.
We see this explicitly in the quote from Sheriff Powell of the Bell County Sheriff's Office. He states, "We understand the community's concern, but we have to work within the confines of the statute."
Basically saying his hands are tied.
Exactly. He is publicly urging the community to engage with the court system to ensure they have the protective orders firmly in place and to immediately alert authorities the moment the suspect trips the wire by stepping onto their property.
It really strips away the cinematic illusion of policing.
Oh.
I mean, they aren't superheroes who can just lock up the bad guy because everyone universally agrees he's a threat.
No, not at all.
They're strict administrators bound by a very rigid, sometimes archaic set of rules. And if the rules say they can't touch him, they have to ask the citizens to help them rewrite the rules on a case-by-case basis.
Which brings us to a crucial macro-level realization about local justice. James Austin Grisham, with his 28 arrests and his terrifying MO, is highly visible. He makes the evening news because his alleged crimes invoke a visceral, primal fear.
Of course.
But from a purely logistical standpoint, he is just one single individual caught in a massive, churning bureaucratic system.
A drop in the bucket.
Exactly. If we truly want to understand why the district attorney and the judges seem overwhelmed, why they can't just focus all their energy on solving the stalker loophole, we really have to look at the sheer volume of the system they are managing.
Right.
What does the rest of the machinery look like on any given day?
To answer that, we pivot to a source document that is, frankly, mesmerizing in its density.
Yeah.
We are looking at the raw MSO automated record system from Bell County.
This is the county jail log.
Yes, the specific timestamp on this document is March 30, 2026 at 17.05.03. That is 5:05 p.m. on a random Monday.
When you look at an automated jail roster of this magnitude, you really have to adjust your perspective.
You do.
You aren't just looking at a list of names and booking numbers. You're looking at a real-time snapshot of a society's missteps, its mental health crises, and its profound administrative failures, all frozen in a single moment.
Yeah.
On this specific Monday evening, there are exactly 1,432 inmates listed on this single report.
1,432 human beings sitting in cells within one county's jurisdiction. And what is so deeply striking about this document, something you really can't grasp until you read the raw data line by line, page by page, is the surreal juxtaposition of the charges.
It's unbelievable.
The system does not differentiate between evil and broke on the intake form. You have literal cinematic villains sitting shoulder to shoulder with people who were incarcerated simply because they couldn't afford to pay a municipal fine.
To illustrate the absurdity and the overwhelming nature of this docket, we need to analyze specific entries. Let's look at how the system overlaps violent felonies with minor infractions.
Okay, let's look at an inmate named Carl Lee Brown. According to the log, he was booked in November 2024. His primary charge is severe, a second-degree felony for aggravated assault causing serious bodily injury.
That is a very heavy charge.
It is. His bond for that specific charge is set at $80,000. He is facing years, potentially decades, in state prison if convicted.
Right.
But right underneath that heavy violent felony, the automated system lists the other active warrants that are keeping him in the county jail. He has a warrant for having no liability insurance with a highly specific fine of $601.90 attached to it.
Down to the cent.
Yeah. And right below that, a warrant for having no driver's license carrying a fine of $349.70.
What this entry reveals is the total convergence of the punitive state and the administrative state.
Wow, yeah.
Carly Brown isn't just being processed as a suspect in a brutal physical assault. He is simultaneously being processed as a citizen who failed to comply with basic roadway financial regulations.
It's wild to see them side by side.
The county jail log tracks the violence that tears the fabric of society with the exact same cold, bureaucratic precision as a lapsed insurance policy. The machine demands an accounting for both.
It gets even stranger when you look at the economics of the jail. Look at the entry for Ashley Dawn Drake.
Okay.
She was booked in March 2026. She is currently sitting on a massive $250,000 surety bond.
Let's define the mechanics of that surety bond because it is crucial for understanding her incarceration.
Please do.
A $250,000 surety bond means the judge has decided she can be released pre-trial, but only if that financial guarantee is met.
Right.
In reality, most defendants don't have $250,000 in cash lying around. They have to use a commercial bail bondsman who will typically charge a 10% non-refundable premium.
So 10% of $250K.
Ashley Dawn Drake would need to hand over $25,000 in cash to a private business just to buy her freedom pending trial. If she doesn't have $25,000, she stays in the cell.
And what is she being held on? The primary charge is possession of a controlled substance, specifically methamphetamine. It's a major drug felony.
Right.
Well, look at what is sitting right next to that $250,000 meth charge. She is also being held on Class C warrants from the local police department. What are the warrants for?
What are they?
Her dog running at large and biting someone, which carries a precise municipal fine of $357.50, and another warrant for her dog not being vaccinated, which is a $227.50 fine.
It completely redefines the cultural perception of a county jail.
It really does.
I mean, we are culturally conditioned to view jails as fortresses meant solely for isolating dangerous predators from the public, but the raw data proves that county jails function largely as administrative holding pens. Severe drug addiction and trafficking sit in the exact same cell block as the ultimate poverty traps.
Poverty traps is the only way to describe it. If you scroll through the hundreds of pages of this PDF, it is an endless, repeating sea of Class C misdemeanors. Expired registration, driving while license invalid, public intoxication, failure to appear for a basic traffic violation.
Over and over again.
You were looking at hundreds of people who were issued a citation, clearly lacked the disposable income to pay a $300 fine, missed their court date because they couldn't take off work, had a bench warrant issued for their arrest, and were subsequently pulled over and locked up.
Yeah.
They were taking up physical space, a bed, and 3 meals a day in a county jail because they couldn't afford a new sticker for their license plate.
And the jarring reality is that nestled directly between those unpaid dog vaccination tickets and the expired vehicle tags are entries of profound, terrifying darkness.
Just randomly scattered in there.
Yeah, you scroll past a driving violation and hit Romy Frantescu, an inmate facing capital murder, tampering with physical evidence, and aggravated assault with a deadly weapon.
Oh my God.
You scroll past a public intoxication charge and find Jiang Xingnai facing multiple counts of a third-degree felony for the smuggling of persons. You find inmates held on million-dollar bonds for unimaginable crimes against children.
So, if I am looking at this entire system holistically, I have to ask, how much does this volume degrade the quality of justice?
Significantly.
If the gears of the system are jammed with 1,400 people, a massive percentage of whom are just broke and driving without a valid license, doesn't that make it infinitely harder for the district attorney and the judges to focus on chronic, complex threats like the serial stalker we discussed in the first segment?
It creates a permanent administrative crisis. The sheer volume of minor infractions dilutes the prosecutorial and judicial resources available for complex cases.
How could it not?
Think about the logistics. Every single entry on that 1,432-person roster, regardless of the severity of the charge, requires a baseline of bureaucratic processing.
Right.
It requires intake paperwork, a medical screening, a guard to supervise their movements, a hearing schedule, and a judge's signature.
All that takes time.
When the physical and administrative apparatus of the jail is forced to process an individual for a $200 dog vaccination fine using the exact same primary intake system as a capital murder suspect, efficiency is just destroyed.
The system becomes entirely reactive.
Yes. It is so consumed by processing the daily tide of bodies and paperwork that it simply lacks the bandwidth to step back, analyze a pattern, and proactively engineer creative statutory solutions for outlier cases, like a chronic stalker.
It is the ultimate bureaucratic grinder. The jail log shows us thousands of citizens who were essentially caught in the gears. They broke a rule, whether it was a horrific, violent crime that shattered a family or a minor administrative failure born of poverty, and the machine mechanically swallowed them up.
That's the passive side of it.
But our next source document introduces us to a very different kind of citizen. A citizen who looks at that exact same machine, understands how the gears work, and decides to actively throw a wrench into them.
Yes. We are shifting our perspective from citizens who are passively processed by the law to a citizen who is proactively, aggressively challenging the law's authority and jurisdiction.
And this is where the source material provides a deeply strange coincidence of county records. We are moving from James Austin Grisham, the alleged stalker trapped in the misdemeanor loop, to a totally unrelated man who happens to share the same last name, C.J. Grisham.
Purely a coincidence, but a fascinating one for our timeline. Let's analyze his profile based on the political campaign announcement provided in the source stack. Who is C.J. Grisham in the context of Bell County?
Well, the document describes him as a U.S. Army veteran, a rancher, and the highly visible head of a political advocacy group called Open Carry Texas. The source article covers his formal announcement that he is running for political office, specifically seeking to represent State Senate District 24.
That's a huge district.
It is. This is a massive, highly consequential district that stretches from the outskirts of San Antonio all the way up to Abilene, encompassing Bell County.
Now, the text outlines a specific, targeted political platform.
Quick note for you listening. We are exploring C.J. Grisham's political platform strictly as it appears in the source material. We are not endorsing any political viewpoints here, left-wing or right-wing. We're simply reporting the facts of his public profile and his legal history to understand how he interacts with the justice system.
Absolutely. So he is positioning himself as a citizen legislator whose primary goal is to stand up to what he views as entrenched career politicians. His platform includes advocating for significantly more permissive gun laws.
Like what?
Specifically, he pushes for unlicensed or constitutional carry, arguing vigorously against previous legislative compromises that restricted open carry only to those who had formally obtained a concealed handgun license from the state.
The article notes that his platform extends beyond firearms, too. He is advocating for traditional values, tough-on-crime legislation, the continued use of the death penalty, mandatory drug tests for citizens receiving welfare benefits, and bolstering the Texas agricultural sector.
A very comprehensive platform.
He also explicitly states his opposition to federal healthcare mandates like Obamacare and what he broadly categorizes as federal overreach. When you read the text, it is clear he is a law and order candidate, but one who is simultaneously highly critical of how the agents of law enforcement interact with constitutional rights, particularly the Second Amendment.
And that critical stance regarding law enforcement is not merely rhetorical or theoretical for him. The source text details a highly significant, highly public intersection between his political advocacy and the local justice system.
This is where his biography becomes a perfect case study for our deep dive into legal mechanics.
Exactly.
The 2013 arrest detailed in the article is a masterclass in the tension between a citizen's interpretation of their rights and the state's mandate to maintain public order. Let's walk through the mechanics of that incident.
Let's do it.
In March 2013, C.J. Grisham was on a hike with his son. While hiking, he was carrying a rifle. Now, the article makes a point to explicitly note that carrying a rifle in this specific manner is entirely legal under Texas state law. He was not violating a weapons statute.
However, legality does not always equate to a lack of friction.
Right.
A citizen legally carrying a firearm in a public space can still generate alarm or confusion among other citizens, which inevitably leads to a 911 call, which inevitably leads to police intervention.
And that is exactly what happened. A police officer stopped him. The dash cam video of this interaction eventually went viral online, and despite the underlying act of carrying the rifle being perfectly legal, the interaction on the side of the road escalated.
As these things often do.
Grisham asserted his rights, the officer asserted his authority, and the friction resulted in Grisham being arrested and eventually convicted. But crucially, He wasn't convicted of an illegal weapons charge because he hadn't committed one. He was convicted of a charge called interfering with official police duties.
That specific charge is fascinating from a legal perspective.
Why is that?
It is a classic, highly subjective, catch-all charge. It is frequently utilized by law enforcement when a citizen fails to comply smoothly or rapidly with an officer's directives during an investigative stop, regardless of whether the initial underlying activity that prompted the stop was legal or illegal.
Wow.
It is essentially a charge that penalizes the friction itself.
It's often referred to colloquially as a contempt of cop charge.
Yeah.
Here's where it gets really interesting, because what happens next is what truly elevates this story into a study of bureaucratic warfare.
The penalty.
Yeah, the penalty handed down by the court for this conviction was a $2,000 fine. Now, for most people, the goal is to exit the grinder as quickly as possible. You write the check, you take the loss, and you move on with your life.
Standard compliance.
But Grisham is an activist who views the system as having fundamentally overstepped its constitutional bounds. So he chose a deeply theatrical, highly burdensome form of protest. When the time came to pay the $2,000 fine to Bell County, he chose to pay the entire amount in nickels.
To really understand the impact of that decision, you have to look at the administrative logistics. Paying a $2,000 legal fine in nickels is not a simple transaction.
It's an administrative nightmare. Let's do the math on the physics of this protest. He stated he did it specifically as a slight to the Bell County District Attorney at the time, Jim Nichols. The pun was intentional. Paid in nickels to nickels.
Incredible.
A single U.S. nickel weighs exactly 5 grams. A $2,000 fine requires 40,000 individual nickels.
40,000.
That translates to roughly 200 kilograms, or over 440 pounds of solid metal coins.
Just acquiring 440 pounds of nickels requires a massive logistical effort with a financial institution. You can't just get that from a cash register.
No.
But the true weaponization happens at the county clerk's office. Under legal tender laws, the county, as a government entity collecting a debt, is generally obligated to accept U.S. currency.
So they couldn't turn him away.
Right. By delivering 40,000 loose coins, Grisham effectively launched a localized denial-of-service attack on the bureaucracy.
A real-life DDoS attack.
He legally complied with the court's order to pay the fine, but he engineered the compliance in a way that maximized the physical and temporal burden on the exact system he felt had unjustly prosecuted him. The clerks had to physically receive, transport, manually verify, and process 440 pounds of metal.
It is brilliant in its sheer pettiness.
Yeah.
But he didn't stop at the nickels. The article notes that he then turned the legal machinery back on the state. He filed a lawsuit against the arresting officer, alleging violations of his Second and Fourth Amendment rights, unlawful arrest, and abuse of authority.
Which perfectly illustrates the profound dual reality of the American justice system.
How so?
We have spent this deep dive looking at the system as a grinder. It is a punitive machine that processes society's rules, punishes deviance, and manages the endless fallout of poverty, as we saw with the thousands of people tracked by traffic tickets on the jail log. It crushes those without means. But C.J. Grisham's story demonstrates the system's second function. It is a constitutional battleground. It is the designated arena where an educated, resourced, or sufficiently motivated citizen can actively challenge the authority of the state, assert their fundamental rights, and legally force the government to justify its actions in front of a judge or jury.
It is the ultimate paradox of local justice. The exact same courthouse that issues a warrant to lock up a single mother because she couldn't afford a $200 dog vaccination fine is the exact same courthouse you can utilize to sue a heavily armed police officer for violating your constitutional rights.
The system is a weapon, and its impact depends entirely on who is wielding it.
That is so true.
The system relies absolutely on its rules to function, but that reliance brings us to a critical vulnerability. What happens when the people whose entire profession, whose entire livelihood, is built on knowing, interpreting, and applying those rules fundamentally fail to do so?
That is the perfect transition into our final source document. We have looked at citizens who are passively crushed by the law. We have looked at citizens who proactively weaponize the law. Now, we are going to look at the operators of the machine.
The professionals.
We're going to look at what happens when the legal professionals themselves drop the ball. And honestly, when you understand the mechanics of what happens here, it is one of the most devastating documents in our stack.
We are examining a disciplinary petition from the Supreme Court of Texas, specifically Miss Docket number 965091.
Which sounds very dry, but it's not.
It isn't. This document is the formal legal mechanism by which the State Bar of Texas, acting through the Supreme Court, seeks to discipline a licensed attorney for professional misconduct.
The attorney named in the petition is Paul Looney, who was practicing out of Harris County at the time. And the victim in this specific scenario is his own client, a man named Watson. Let's walk through the timeline of this professional failure, because it highlights the terrifying rigidity of the system for a citizen, contrasted with the devastating consequences of a lawyer's negligence.
It's a really sad case.
Watson was convicted of a criminal offense, and he hired attorney Looney to handle his appeal. The basis of Watson's appeal was not frivolous. It was highly substantial. They were arguing that the trial court made a critical error by allowing an alleged oral confession to be admitted as evidence against him.
From a procedural standpoint, the admissibility of an oral confession is a massive constitutional issue.
Right.
It frequently makes or breaks a criminal prosecution. Navigating the appellate courts to challenge that admissibility requires deep technical expertise. The appellate process is not a retrial. It is a strict, highly regimented review of the trial's written record to hunt for procedural errors.
So Watson pays Looney a retainer fee of $5,000 to manage this highly complex legal maneuvering.
To put that in perspective, this timeline occurs in the mid-1990s.
Yeah, $5,000 is an incredible amount of money for a defendant or their family to scrape together to secure competent defense back then.
Oh, absolutely.
So, Looney cashes the check and takes the case. The first major hurdle in an appeal is filing what is called the Statement of Facts with the Court of Appeals. The disciplinary document explicitly states that the absolute deadline to file this foundational document was on or before March 10, 1994.
And what does Looney, the licensed expert, do?
He fails to file it. He completely misses the deadline.
And we must emphasize how unforgiving appellate courts are regarding deadlines. A trial court might grant you a continuance if you have a good excuse. Appellate courts operate on a doctrine of finality. Deadlines are jurisdictional.
What does that mean, jurisdictional?
It means if you miss them, the court literally loses the legal authority to even hear your argument, regardless of how valid your constitutional claim might be.
Wow.
But Looney's negligence compounded. Over a year later, the process dictated that he needed to file a petition for discretionary review with the Court of Criminal Appeals, which is the highest criminal court in the state of Texas.
This petition is the final lifeline. The absolute deadline to file this petition, or at the very least to formally request an extension of time, was March 11, 1995. And once again, Looney misses the deadline.
Again.
He doesn't file the petition until April 10, 1995, an entire month late.
And, as expected, the Court of Criminal Appeals operates with zero tolerance for a missed deadline of that magnitude. On May 3, 1995, the court outright dismissed Watson's petition. They threw the entire appeal out.
Just gone.
And it is vital to understand that they did not throw it out because Watson's argument about his coerced confession was legally incorrect. They threw it out entirely because his lawyer failed to submit the paperwork on time. The merits of his freedom were voided by an administrative failure.
Which leads to the formal charge in the document. The petition charges Looney with violating Rule 1.01 of the Texas Rules of Disciplinary Procedure, specifically focusing on neglecting a legal matter entrusted to him and fundamentally failing to carry out the basic obligations owed to a client.
But the cold legal phrasing really doesn't capture the human tragedy here.
It doesn't. How did Watson, the client whose life was on the line, actually find out that his appeal was dead? Did his lawyer call him to apologize? Did he offer a refund?
No. The petition explicitly states that Looney utterly failed to inform his client of the status of the case, despite numerous desperate attempts by both Watson and his family to contact the law office.
Watson only found out that his appeal was dismissed because he was sitting in a state prison cell, and he took it upon himself to go to the Texas Department of Corrections Law Library.
Yeah.
He manually looked through the printed appellate updates, the bulletins that list the status of cases across the state, and he found his own name listed under the dismissed cases.
Try to conceptualize the profound isolation of that exact moment in the library.
I can't even imagine.
You have paid thousands of dollars to an expert. You are relying entirely on their state-sanctioned license to navigate a labyrinthine system that is designed to be virtually impossible for a layman to navigate from the inside of a prison. You are waiting for news of your freedom, and you discover the ultimate professional betrayal not from a conversation, not from a letter from your attorney, but by reading a sterile library update bulletin that tells you your legal avenues are exhausted.
It is a gutting realization of powerlessness. But the document doesn't just show us the failure. It reveals how the legal system eventually polices its own operators. And in a truly unbelievable twist of fate, for the specific documents we pulled for today's deep dives, look at the name of the judge who was formally assigned to oversee the disciplinary action against this attorney.
It is addressed right at the top of the administrative letters, "Dear Judge Grisham."
We have hit the Grisham trifecta in Bell County.
We really did.
We started with James Austin Grisham, the alleged stalker trapped in the system. We moved to C.J. Grisham, the political activist weaponizing the system. And now we have Judge Grisham, the arbiter enforcing the rules of the system upon its own professionals.
It is a striking reminder of how interconnected and incestuous these county and state legal networks truly are. But look at the instructions detailed in the letter to Judge Grisham. Holding a lawyer accountable is not a swift process.
Not at all.
The letter outlines a staggering, multi-step administrative labyrinth just to initiate the disciplinary proceedings. The system wraps its own operators in layers of procedural protection.
Let me list it out. Judge Grisham is informed that he has to wait 6 to 8 weeks just to find out which specific district court the case will eventually be assigned to.
6 to 8 weeks.
Then, he has to coordinate with the administrative office to reserve a physical courtroom and secure a court reporter. He then has to contact the presiding judge of the administrative region to navigate lodging, travel, and expense claims for the hearing.
And this brings us to the core contradiction that encapsulates everything we have unpacked today. Look at the disparity in how the law applies its mechanism.
Oh, the double standard is huge.
The system is incredibly, mercilessly rigid when it comes to the public. If Watson misses a deadline by a day, his appeal is permanently thrown out and he remains locked in a state penitentiary.
Yep.
If a citizen in Bell County forgets to pay a $200 dog vaccination fine, a warrant is immediately issued, and they are tossed into a cell alongside a capital murder suspect, becoming one of 1,400 names on a daily roster. The grinder works swiftly and bluntly against the poor, the unrepresented, and the minor offender.
But when it comes to punishing a negligent lawyer, one of the system's own credentialed operators, the process suddenly requires this intricate, heavily insulated, multi-step, months-long Supreme Court disciplinary assignment just to schedule a hearing.
It speaks volumes about the hierarchy of access to justice. The mechanisms of accountability for those who hold the keys to the bureaucracy are buffered by extreme procedural caution and professional courtesy, while the mechanisms of punishment for those at the bottom are highly automated and intensely unforgiving.
We have covered incredible, deeply complex ground today, so let's synthesize this journey. We started this deep dive by examining the agonizing, cyclical reality of a chronic misdemeanor offender.
Right, James Austin Grisham.
We saw how the 19th century focus on property rights in the penal code utterly fails to protect modern victims from psychological terror, forcing terrified citizens to personally navigate the civil courts to build their own legal traps just to secure a felony charge.
From that micro-level failure, we zoomed out to look at the macro-level reality of the 2026 Bell County Jail roster. We explored the staggering volume of the system, revealing how the bureaucratic machinery processes severe, violent felonies through the exact same clogged administrative arteries as minor municipal poverty traps.
Which dilutes the system's ability to effectively protect the public.
Precise.
We then pivoted to the proactive defiance of a political activist, exploring how a legally savvy citizen can utilize the dual nature of the justice system, transforming it from a putative grinder into a constitutional battleground, culminating in the logistical warfare of paying a fine with hundreds of pounds of nickels.
And finally, we dissected the quiet, devastating failures of the legal professionals themselves, leaving a client to discover his own doomed fate in the silence of a prison law library, while the system slowly organized its insulated disciplinary response.
What this collection of documents definitively demonstrates is that the law is not a pristine, logical algorithm functioning perfectly in a vacuum. It is a profoundly human bureaucracy.
It is flawed, it is frequently overwhelmed by its own volume, it is slow to adapt to new definitions of harm, and it is rife with internal contradictions regarding who it punishes swiftly and who it protects procedurally.
And that is exactly why we do this show. We want to reiterate to you, the learner listening right now, that being truly well-informed in today's world requires looking far past the sensational, easy-to-digest headlines.
You really have to dig deep.
If you want to understand your society, you have to look at the actual mechanics of governance.
Right.
You have to read the dry paperwork. You have to understand the historical constraints of the statutes. And you have to recognize the sheer, messy human element that is constantly clogging the gears of justice. That is where the actual truth of our legal system lives.
It lives permanently in the friction between the ideal of the rule of law and the messy, voluminous reality of human behavior.
And as we wrap up, we want to leave you with a final lingering question to ponder something that builds on every single document we've explored today. We talked extensively about the concept of the legal electric fence. If our local legal system is so rigidly bound by outdated statutes and so overwhelmed by administrative volume that a man with 28 arrests for stalking requires everyday citizens to individually file paperwork just to build a bureaucratic trap for a felony charge, who is the system actually designed to protect?
Is it fundamentally structured to protect the community from harm? Is it designed to protect the constitutional rights of the offender? Or, at the end of the day, is it simply operating to protect the bureaucracy itself from collapsing under its own weight?
Thanks for joining us on this deep dive. Keep questioning the mechanics.